Welcome to the debate. Today we are immersing ourselves in quite a detailed formal report concerning what's being termed tribunal fraud. This stems from Special Tribunal Matter ST0615, and it involves RBC Royal Bank and the Estate Police Association, or the EPA. The material we've got here, well, it lays bare some really severe alleged breaches of evidential integrity. These breaches seem to strike right at the heart of our judicial system.
It's genuinely explosive material. And its significance, I think, goes far beyond just the original labor dispute. The core finding, as you said, is that false sworn statements and the deliberate use of superseded documents were introduced into the court record. And this foundation of fraud, well, it apparently tainted every single subsequent judicial proceeding, including a matter that went all the way up to the Privy Council, our highest court of appeal. It really does suggest a calculated strategy to deceive multiple levels of the judiciary.
Yeah, that level of systemic compromise makes this essential reading. We're not looking at a simple mistake here. The report points to clear violations of multiple statutes. The Perjury Act, certainly, the Forgery Act, and also the Industrial Relations Act, the IRA. So this combination of legal offenses forces us to ask a difficult question about accountability. Given the undeniable illegality, where does the primary burden of culpability actually lie? Does it rest with the individual officers, specifically Robert Ramatar, Asif Ghafoor, Ricky Cimarrome, Assam Baska, and Curtis Burnett, the ones who physically signed and swore those false affidavits?
Or, on the other hand, does the main criminal and ethical responsibility fall on the organization, the union, the EPA, and, critically, its legal representatives, Clay Hackett and Harrison Thompson? These are the people who allegedly designed and orchestrated this entire fraudulent evidential strategy and then submitted it to the courts. That tension, between the individual's action and the professional or organizational command, that's really the crux of what the report is asking us to consider.
Right, and I'll be arguing today that accountability fundamentally rests with the individuals who signed those oaths. The individuals are, in the end, the ultimate guardians of truth within any judicial process.
And I'll argue that while the officers certainly committed a consequential crime, the greater culpability, the primary responsibility, lies with the professional agents and the union itself. They had the legal know-how and, it seems, the organizational intent needed to carry out and sustain what looks like systemic fraud.
Okay, so my position is really rooted in the absolute sanctity of the judicial oath. I mean, the integrity of any court proceeding, whether it's a special tribunal or even the Privy Council, is completely dependent on the truthfulness of sworn testimony. The 5 officers named in the report directly contravened the Perjury Act, Chap 11.14, Section 3. The report highlights what seems to be an irreconcilable contradiction in time. These individuals swore they were retrenched, meaning their employment ended, in May 2015, effective May 16, 2015. Okay? But then, apparently to satisfy a legal requirement, they simultaneously testified they received a 45-day notice letter dated way back on May 26, 2014. Now, that May 2014 notice, if valid, would have ended their employment in July 2014, a full year before the actual retrenchment date they cited. The two facts just cannot coexist. They're mutually exclusive. The really critical point here for me is that regardless of the legal advice they got, or any organizational pressure, or even what motivated them personally, the physical, willful act of signing and swearing to the truth of these incompatible dates under oath that places the burden of responsibility squarely on the individual signatory. They violated both the Perjury Act and the Oaths Act, Chapter 7.01, Section 9. They effectively created the foundational legal fiction that was needed for this whole case to even get off the ground.
Okay, I absolutely agree that the violation of the Perjury Act is undeniable. It's right there in the facts presented, and it's certainly consequential. However, I think accountability has to be weighed against the intent and the overall scope of the offense. I believe we really need to focus on the professional architects behind this scheme. This wasn't just, a simple mistake made by an individual perhaps feeling pressured.
The report strongly suggests a deliberate, organized legal strategy used by the EPA and its representatives specifically to, and I quote, fill legal gaps. The specific evidence the report points to is documentary fraud, which falls squarely under the Forgery Act, Chap 11.13, Section 3. Now, this act criminalizes the knowing use of documents with intent to deceive or defraud. And to grasp the severity here, we need to understand the Retrenchment and Severance Benefits Act, the RSBA. That law required the employer to give 45 days notice before retrenchment. The bank, RBC, apparently failed to do this correctly for this group. So, the union and its counsel, specifically Mr. Hackett and Mr. Thompson, according to the report, allegedly manufactured a solution. How? By repurposing irrelevant letters from 2014 meant for a different situation entirely to retroactively look like they complied with that crucial 45-day requirement. This action, the professional deployment of essentially falsified documents to fix a known sophisticated legal problem, that's where I argue the primary criminal responsibility lies. They orchestrated what the report calls the bad faith submission of evidence, directly violating Section 34(2)(c) of the Industrial Relations Act as well.
I see why you emphasize the strategic planning and the role of the legal agents in, finding and using those documents. But let me offer a slightly different perspective, one focused really on the gateway into the judicial record. The officers weren't just passive bystanders here. They were active participants in validating the lie. The fraud shifted from being, let's say, a dubious legal strategy cooked up by counsel, an internal organizational plan, into a legally actionable crime the very moment those 5 officers put pen to paper and affirmed that affidavit. Think about it like this. Harrison Thompson or Clay Hackett, they can draft a document, sure, but that document only becomes evidence, only gains legal standing when someone swears it's true. The officers knew, or absolutely should have known, that the 2014 dates contradicted their own timeline. That contradiction wasn't buried in fine print. It was the core assertion they were swearing to uphold. It's telling, I think, that the report's recommendation for a criminal investigation focuses on the Perjury Act first, targeting the signatories. That seems to underscore the systemic importance of that initial individual breach. The lie, however it was conceived, had to be certified, had to be authenticated by the very people it concerned.
That's a compelling point about the act of certification. I grant you. But have you considered let's call it the organizational power structure that was likely at play? The source material explicitly notes the documents were misrepresented by the EPA and its agents. It suggests the agents were actively misleading the tribunal on at least 2 key counts. First, by confusing the court about who the legitimate employing entity even was, referencing this enterprise services. And second, by essentially fabricating valid notice dates using those old letters. Now, the individual officer, and we probably should acknowledge the internal dynamics here, the kind of pressure one might face when their legal counsel, represented by people like Harrison Thompson, and their powerful union leadership are directing them towards a certain action, is likely signing an affidavit that was prepared entirely by counsel. In this view, the officers might be seen more as foot soldiers. The actual intent to defraud the court via the Forgery Act violation, that seems to rest more clearly with the legal professionals. It takes legal expertise, after all, to recognize the specific 45-day RSBA gap and then deploy a specific falsified document to try and plug it. The professionals, they have a duty not just to their clients, but a fundamental duty to the court itself, which seems to have been breached here.
I understand the argument about potential duress or, following an organizational directive, but frankly, if we accept that a lay witness, even if they feel pressured by their own counsel, is somehow excused from the fundamental duty to tell the truth under oath, well, we undermine the entire legal process. The integrity of the oath has to be absolute, doesn't it? We can't build a system where perjury becomes just an accessory crime, secondary to a fraud orchestrated by lawyers. If an officer knew they were swearing to a flat-out contradiction, and the report strongly implies they did, they had a choice.
By signing, they provided the essential authentication, the key, that the union's strategic fraud needed to become legally potent.
I come at it from perhaps a different angle, focusing on the nature and scale of the damage inflicted. The material makes it crystal clear that this submission of false evidence directly influenced all the subsequent cases, SD 615 itself, the judicial review that followed, the appeal court decision, and even the Privy Council matter. This wasn't some localized error contained to the first instance. It was a foundational collapse that, well, it metastasized right up through the judiciary. The power, the ability to initiate, sustain, and continue this apparently illegitimate litigation for years that rests overwhelmingly with the union and its sophisticated legal team, wouldn't you say? The 5 officers, remember, were just a fraction of the total group affected by the retrenchment. I think it was 5 out of 42. But their specific, allegedly false evidence was the linchpin used by the professional agents to keep the fraud alive, pushing it through multiple, costly, high-stakes appeals. To me, that points directly to institutional failure and, frankly, egregious professional misconduct. The officers might have enabled the fraud at the start, yes, but the legal professionals were the ones steering this compromised ship all the way to the highest appellate body. Their actions didn't just taint a case. They arguably compromised public trust in legal representation itself.
That's an interesting point about the scale of the damage, the propagation through the system. Though I would frame the origin of that taint differently. The contamination originates precisely at that critical moment the false affidavit is formally entered into the court's record. Without that foundation laid by the officer's false sworn statements, the EPA's entire case in ST 0615, it simply couldn't have moved forward. If those 5 officers had just refused to swear to 2 contradictory facts, if they had simply upheld their clear legal duty under the Oaths Act, then all the subsequent legal maneuvers, the ones designed specifically to overcome the bank's failure to provide valid 45-day notice, they would have collapsed right there, immediately, at the tribunal level. The immense expense, the judicial time wasted, the systemic damage that reached all the way to the Privy Council, all of that was predicated on that initial validation of the lie by the officers. The officer, specifically Robert Ramatar and his peers named in this, they were the ultimate guarantor of truth for their own sworn testimony. They were the weak link, perhaps, that allowed this institutional fraud to enter and then leverage the entire court system.
I'm sorry, but I just don't buy that the professional orchestration is somehow secondary here. Let me tell you why. The report specifically identifies the core offenses as the misuse of employer letters and the related documentary forgery, repurposing letters meant for another group, referencing an entity, this Enterprise Services, which apparently had no legal standing regarding these specific officers' employment. Now, executing that kind of maneuver required deep, systemic knowledge of the case's specific legal weaknesses, particularly how the RSBA's statutory 45-day requirement could be fraudulently addressed. The officers may well be accessories to the perjury, I wouldn't dispute that, but the architects of the documentary forgery, the clear violation of the Forgery Act, that seems very clearly to be the sophisticated agents Harrison Thompson and Clay Hackett named here, who were consciously attempting to fill a critical, known legal gap. When we discuss primary culpability, surely we must look at who created the necessity for the lie in the first place, and who possessed the higher professional duty to refrain from utilizing falsified evidence in a legal setting. The professionals who knowingly deployed fabricated evidence to deceive the tribunal, they committed the greater ethical and systemic breach, in my view.
But that professional duty, while absolutely critical, it doesn't somehow absolve the individual of their non-delegatable personal responsibility when they take an oath. If the officers were pressured, or, as the material might imply, perhaps actively led into this action, they were still the ones who certified the lie as truth before the court. The report demands disciplinary action against both sets of actors, doesn't it? Precisely because the 2 offenses, the perjury by the officers and the forgery potentially orchestrated by the agents, are mutually dependent here. They needed each other for the fraud to work. The crucial distinction for me remains that the oath is the most fundamental, most protected element of judicial truth-seeking. If we start making exceptions for perjury based on, well, external pressure or bad advice, we completely devalue that essential currency.
We have to hold the individual accountable for upholding their oath, just as we absolutely must hold the professional accountable for upholding their distinct, arguably higher duty to the court.
And that is exactly where the debate sharpens, isn't it? Because if we focus only or primarily on the perjury of the 5 individuals, we risk, perhaps inadvertently, allowing the institutional actors, the powerful union and its retained counsel, to maintain a degree of operational impunity for allegedly orchestrating the whole thing. The systemic damage caused by a lawyer knowingly deploying falsified documents, well, it's arguably far more corrosive to the rule of law in the long run than the perjury of a lay witness who may genuinely have been coerced or simply profoundly misled by those they trusted for legal guidance. Accountability, I still maintain, must begin or at least be weighted more heavily towards those who hold the highest professional duty and possess the greatest power to manipulate the system itself.
So, in summarizing my position, while I fully acknowledge the critical and, frankly, severe role the legal agents appear to have played in orchestrating the submission and potentially creating the documentary fraud, the initial legal fiction, the thing that allowed these tainted proceedings to even begin, was affirmed under oath by the individual officers. They violated the most fundamental principle of judicial integrity by swearing false statements, providing the necessary spark, if you will, for the institutional fire that followed. The individual act of perjury, therefore, remains the foundational offense against the judicial record itself.
And conversely, from my perspective, the sheer complexity of the violations described, particularly the calculated documentary forgery designed to overcome a specific statutory weakness, and then the repeated bad faith submission of that evidence up the judicial chain, all of that necessitates focusing accountability squarely on the professional conduct of the EPA and its attorneys. Their deliberate, high-level strategic actions appear to have compromised the entire judicial process, from the tribunal right up to the Privy Council. This justifies, I think, the report's strong recommendation for an Integrity Commission referral alongside the criminal investigation covering both the perjury and the forgery acts.
Yes, the material provided is quite clear. It mandates immediate investigation and disciplinary action. And the specific referral to the Director of Public Prosecutions for review under both the Perjury Act and the Forgery Act underscores that both individual signatories and the institutional actors must face scrutiny for their distinct yet clearly interconnected roles in this alleged fraud.
Absolutely. The report really highlights that understanding the full scope of responsibility here requires carefully parsing the distinct legal and ethical roles played by all the parties involved: the officers who swore the oaths, the union that represented them, and the legal professionals who built and argued the case. It's a chilling reminder that fraud, once it enters the official record, can potentially sustain a legal fiction all the way to the highest court in the land. There is clearly much more to explore in this material as these investigations hopefully begin.